Mistake number 8. Failing to prepare for the trial. Jurors often find that actual trials are boring, repetitive, and confusing when compared to what they see on television. Many times, jurors do not even completely understand the difference between the competing versions of what happened. A poor trial presentation is often the attorney's fault, but the blame can be shared when the defendant does not help the attorney present a better case. The attorney should ask the defendant questions about who was at the scene, what the witnesses will probably say, how the attorney can locate the witnesses, whether the event was captured on video, and the history between the defendant and the prosecution's witnesses. These questions should help gather evidence, but let's be fair. Your lawyer is not a private investigator. It is not the attorney's job to find a guy who goes by JoJo and who used to live across the street. If you need actual investigative services, then you should have your attorney coordinate with an investigator or hire an investigator yourself. If you can't afford an investigator, then you better do the digging on your own. It is common for the defendant to tell the attorney on the night before trial something like, "Hey, I have a witness who saw the whole thing." Naturally, the defendant will believe that this still provides enough time for the attorney to use this witness. However, by this time, the witness might have moved to another state, can't remember the details, or won't take a day off of work to attend the trial. A defendant might also say, "There is a security camera that recorded the entire thing, but since they haven't told the lawyer that for 6 months, the recording is long gone." A good attorney should begin asking questions well before this time in case the defendant doesn't know to bring up these facts, but the defendant does not need to wait to share this information. These last-minute announcements present 2 problems. The first problem is that evidence and witnesses aren't always immediately available. Many people don't care if you're looking at a 20-year sentence. They ain't coming to court to testify unless your attorney issues a subpoena for them so that they do not lose a day of vacation. Security camera footage, 911 recordings, and witnesses take time to locate, especially when that evidence is in the hands of law enforcement or a private company. The second problem is that the attorney is required to provide evidence that he or she plans to use much earlier than the day before trial. In the same way that the state gives our discovery, or evidence that will be used against us, we have to give reciprocal discovery back to the state when we receive it. If a defendant hands me something on the night before trial, no matter how much it would help the case, I cannot introduce it into evidence because I haven't given it to the other side with the time limits required by the rules of criminal procedure. It isn't like on TV, when an attorney's assistant bursts through the courtroom doors at the last second, holding up a piece of paper that wins the case. Defendants often think that just saying something like, "We just received this," will make it okay. But judges don't just say, "Oh, okay, well then let's throw out the rules of criminal procedure since you just got it." If this piece of evidence is something that was available months ago, and it was only received at the last minute due to delay on the attorney or defendant's part, the judge will usually keep it out of the case. While it doesn't make good television programming, trials are not like that book report you finished in 10th grade after pulling an all-nighter. Trials require preparation that occurs weeks and months beforehand to get the best results. That's not to say that you have to work continuously for multiple months in every case, but you have to have provided certain things in advance of the case or the judge will likely rule them inadmissible. Great trial attorneys will appreciate this famous quote from Muhammad Ali. "The fight is won or lost far away from witnesses, behind the lines, in the gym, and out there on the road, long before I dance under those lights." Trial excellence is the result of fact gathering, witness preparation, legal research, effective pretrial motions, focus groups, exhibit preparation, and all these things happen way before the first day of trial. If your attorney isn't asking the right questions or preparing with you in advance, then it may be his or her fault. If you aren't meeting with your attorney or providing him or her with the information needed, then it may be your fault. Regardless of where the blame lies, you will be the one paying the price by getting convicted and going to prison. Don't let a winnable case turn into a loser merely due to a lack of adequate preparation. There will always be plenty of last-minute developments when your case goes to trial. Criminal defense attorneys rarely have any idea whether the witnesses can be located, what the witnesses will say, which witnesses will be called to testify, and whether the witness testimony will match the forensic evidence in the case. This occurs because the prosecution does not have to give us copies of witness statements. Your attorney still has to deal with lots of last-minute revelations. So don't add to the list by expecting them to get 10 new exhibits squeezed in at the last minute. Even if you are able to get the evidence admitted by some miracle, your attorney may not have enough time to figure out the best ways to use it.